Mr. Donovan.
My Lord, before I resume on ground 4, just one point picking up on my Lord's question earlier about the Chinese Community Centre.
Oh, yes.
So the short answer is that I was right in my proportions. That's because there's not been any other restriction on the costs as they pertain to the building as regards the Chinese Community Centre. So that's just part and parcel of the whole, as it were. So the costs of property that relate to that part of the building, the Chinese Community Centre, are treated in just the same way under the method as costs in respect of any other part of the building. So before the lunch adjournment, we were discussing the scenario where the onward use of the business entertainment was wholly for exempt purposes. And we'd worked through the example and we got to the wrong answer when applying my learned friend's methodology. The position is no happier if you address the scenario on the premise that the business entertainment use is wholly for taxable purposes. And so if you remember, I had 3. This is the first one. And this is the one that the appellant says, oh, well, in this instance, the input tax order does bite. So, you know, wet towel around head, proceeding at 4th, we have the same residual input tax cost of £30,000 being used for £1,000 of business entertainment supplies to further taxable supplies, and then 1,000 for exempt, 1,000 for taxable. Now, HMRC's analysis is exactly the same, because you say, well, a third of it is for business entertainment, so we take that off first. So we're left with £20,000 of those residual costs, which you feed into the partial exemption calculation, and you get 50% of that. So you get £10,000 as recovery. And again, that accords in our submission with it being a third used for a taxable supply. So to my learned friend's analysis. He goes first to the partial exemption regulations. So he has £30,000 of input VAT, and the standard method produces a 50% recovery. So he gets £15,000 from section 26 into section 25. And then this is the scenario where he says, oh, well, the input tax order does now apply because that input credit of £15,000 includes tax which has been used for the purposes of those business entertainment for taxable transactions. And my Lady Justice Whipple asked my learned friend, well, what happens then? How do you work it then? And the answer was, well, you do a commercial apportionment. So if I understand my learned friend's proposed logic, that is to say, well, you've got 15,000 representing the immediate taxable use and also the entertainment for taxable use. Both of those, you've spent you've got £1,000 worth of supplies. You've used them for £1,000. So effectively, half of it is business entertainment and half of it is taxable. So that's the point.
I don't think he does, because I think in his business entertainment, he's got £1,000 worth of residual. This is why it's quite something if this is what we're meant to be doing. You've got £1,000 attributed to business entertainment, but that's across both taxable and exempt business entertainment. Well, his version, because you look at which business it's supporting at the end of the day.
I think I've maybe misspoken. So you've got £15,000 of input VAT credit.
Yes. And
then you're saying that we need to now split
something needs to be clawed back out of
as between the use that has been for entertainment and the use that has been for taxable direct.
Okay. And what's our hypothesis here, that you've only used business entertainment for taxable? Is that
Yes,
what our
exactly.
starting hypothesis?
So that's why we're taking.
Yep, okay,
That's why
yep,
we're at the point. And then the amount that you're then restricting, because you've used it for £1,000 worth of free entertainment and £1,000 worth of taxable supplies, they're the same. So if you restricted the 50% of that credit to split it as between the amount of that credit that you've used for taxable, the amount of that credit that you've used for entertainment, you get £7,500. So again, you get to the wrong answer. So in the scenario where...
So does this work out worse for them? If business entertainment was all for tax, I mean, if you were allowed to look to the ultimate purpose, which I think is quite a troubling proposition, but let's say for the moment you are. In fact, if it's all taxable, it works out worse for them.
Exactly.
But of course, it's not all taxable. So I dare say in here there's an advantage for the
Exactly. So where it's all exempt, you get more recovery.
Yep.
When it's all taxable, you get less. And when it's a mix, well, it depends on which side the line it is. But on any view, it doesn't get to the right answer in my submission.
Yeah.
The second point is that a perfectly reasonable and workable construction of Section 25 is possible. So if we go to Section 25, which we find on page 95 of the authorities, tab 3, effectively, it is the construction that the Upper Tribunal adopted, which is at 25.2, where it has, subject to the provisions of this section, you then go first to subsection 7 and the input tax order to undertake the entertainment block, and then say you're entitled to the amount that you get from Section 26. So you do the block first, and then 26. Now, I do understand my learned friend's submission on the construction and how it's possible to read this technically as suggesting, well, you're only restricting credit, so you have to get the credit in first because that's what's being restricted. But it gets to the wrong answer. And that alternative construction, which is to say you do the business entertainment restriction first, is in no way an impossible reading of these provisions. And then the third point is that Thorne EMI supports such a purposive approach, or a commonsensical approach. And we've already looked at Thorne EMI, and you'll recall it was a distinct question of whether you could have an apportionment of a cost as between entertainment use and taxable use. But if you could kindly turn to page 197 of the authorities.
Was Thorne, was it, just remind me, was it business, non-business, or was it something else?
No, this was the chalet that was being partly used for entertainment.
Show. Okay, so it wasn't business entertainment. Yep.
So picking it up at page 194.
Yeah.
Page 194, tab 5, I think it is. And then you see my lady, in the paragraph starting the company's appeal just before F, concerned with the input tax and the supply of hospitality chalets. And then if you go through down to 4 within that paragraph, below G, in the use of the chalets, the element of business entertainment predominated, but there was also some business non-entertainment use, which was not de minimis.
What's business non-entertainment use?
I
Is
think
that what I
just
call a
business
taxable?
use, isn't it?
That's a business use.
Business
So
use.
what does that mean? Sort of negotiating contracts or something like that?
They'd had some meetings or something.
Meetings.
hadn't
Yes, exactly. Business discussions sometimes took place,
Yes, okay.
as well as, sorry, I took it too quickly, always the danger at 1.
Got it.
And so the deduction of that part which was related to non-entertainment use had not been allowed, and so it came to before the Court of Appeal saying, well, surely we have a right to the bit which we did use for taxable purposes. Picking it up at 197, this is Lord Justice Millett's judgment, and at B, you have his conclusion that a provision for apportionment between entertainment and non-entertainment use must be implied into Article 9(1). And he gives his reasons as follows, and can I just invite you to read the first 2, please?
Yeah.
So I draw attention in particular to the second, because the point being made there is that under section 24, which is about the non-business apportionment, you know, if you use something partly for non-business and partly for business, then there is allowed to be apportionment. And the point Lord Justice Millett's making it too is that it's impossible to believe that anything different should apply when you get to the entertainment restriction under section 25. And what I would draw from that, in the present case, is that in a similar way, section 24 operates to block recovery for non-business use, and there is no argument along the lines that my learned friend is articulating with
What
respect
about
to
sort of when it
entertainment.
happens? You do that at the
Exactly,
beginning. Okay.
exactly. It might be that there's ambiguity in the way that section 25 has been drafted in the way that my learned friend says. But stepping back, it's hard to think that the same sort of logic shouldn't apply, namely looking at it commonsensically. It's hard to believe that this section has been drafted in a way that doesn't simply result in a simple block of business entertainment.
I think one of the arguments is, isn't it, that the mechanism for business non-business is very different from the mechanism that's
And I
suggested in
accept
Article 9. But you say
I accept.
distinction without a difference.
Well, I mean, it's a technical distinction.
Yeah.
But that's why I say, stepping back and looking at it, it gets to the wrong answer. And the logic of Lord Justice Millett's analysis in this case is, well, you have to get to the right answer. It's supposed to work so as to stop recovery insofar as something being used non-business or entertainment, but allow it insofar as it's being used for taxable business. So the outcome, as I was postulating just after lunch, in that it's purely used for taxable purposes, the entertainment, and getting the reduced amounts of tax. It's contrary to the plain purpose of these provisions. And you see that picked up at 4, at least the sort of purpose of reasoning. The exclusion of all credit for input tax in the present case would deny the company the basic right of deduction.
But this is an EU point and you're not pursuing one.
Well, in terms of the right of deduction for use for taxable business, that's not my retracted EU point. I mean, that remains the case. So the point remains that insofar as the logic from my learned friend's analysis is that in that pure use for taxable scenario, you get less deductible input tax than you should.
And the offence, you would say, is that means that your block, because it's applying at the stage that you're applying it, where you've already identified what would otherwise be recoverable residual input tax because attributable to taxable supplies, that offends the sort of basic
Yes,
principle?
so getting £7,500 when you used it for £10,000.
For £10, exactly. There's a mismatch.
The one point in your question, I think, which isn't right, is that it's not that the £15,000 is the right amount either.
No, okay.
But yes.
But even if you were just looking at the bottom line.
Yes, exactly.
And I'm sure you could play with the numbers in the scenario and come up with all sorts of different things.
Exactly.
But on your scenario, the problem is that you only get £7,500 worth of input tax back, even though you have used the whole pot of 30,000. You've made £10,000 worth of taxable supplies.
You've made
£1,000
£1,000
worth.
Sorry. You've made a third of the 30 has been used for taxable.
Yeah.
So you should get.
So you have made £10,000 worth. Is that right?
You've used £10,000 worth.
Okay.
Because the £30,000 is the input tax that we're apportioning.
I see. Okay, I'm going the wrong way around. Okay.
But you've used it for a third, but in the same way, the other scenario offends too. So the one that's close to the facts of this case, where you've still only used it for a third's worth of taxable, but you're recovering half of the input tax. So too, if we turn the page 298, so Lord Justice Hobhouse's decision, and then the highlighted, sidelined part at D, so if in respect of an indivisible supply used partly for entertainment, that is partly for a non-business purpose, partly for business purposes, still entitled to deduct the amount that you spend in business. Now, Learned Friend is quite right to say, well, strictly when he says it equates the use for entertainment as a non-business purpose, that doesn't make sense because that's already been done in section 24. Yes, I mean, that is strictly right. But that's to miss the wider point, which is in effect what he's saying there, is it's partly for something that you don't get a right to deduct for, and partly for something that you do, and you can recover to the degree to which it's your taxable. So that's what I'm saying. Lord Justice Hobhouse is effectively saying there. When he's equating use for entertainment, that is partly for non-business purpose. He's effectively saying, it's in the same ballpark of use for something you don't get a recovery for. Now, as I say, I'm not saying he's technically right in discussing it in those terms, because non-business use has been dealt with at an earlier point. But stepping back, what you have is the Court of Appeal clearly construing this difficult piece of legislation, which didn't have the apportionment, in a way that gave rise to the right answer. And HMRC's and the Upper Tribunal's construction of how this business entertainment block works gets to the right answer. The appellant's contentions do not. And for those reasons, this fourth ground must also fail. So my Lord, my ladies, unless I can assist further, those are my submissions.
No, I don't detect any more questions, so thank you very much, Mr. Donald. Mr. Hitchby.
Thank you, my Lord. Let me start, if I may, by going back to our first round of appeal, and our principal criticism of the Upper Tribunal. That's the criticism we identify in paragraph 61 of its decision. I won't take you back to it, but that's where it drew a distinction between adequacy of reasons and lack of reasons. You'll recall the paragraph. Now, in responding to the tribunal's observations on that, in that paragraph, my learned friend said, well, wouldn't it have a look at award drinks, which the tribunal cites from in the next paragraph of its decision, paragraph 62. And in award drinks, it says, well, failure to give reasons or sufficient reasons is an error of law. Well, of course it is, but that rather misses the point, because our complaint is that whether you're dealing with a case where inadequacy of reasons is alleged, or a case where a lack of reason is alleged, the approach that should be adopted is the same. The principles that should be applied are the same. Now, my learned friend goes on to say, well, essentially what Mr. Hitchmo is complaining about, he says, is an evaluative judgment that the Upper Tribunal reached. And he's right to an extent. I am complaining about an evaluative judgment. But if that evaluation has been reached by applying incorrect legal principles that are flawed, which we allege is the case here, then that value judgment is of no worth. Now, I say all that, but then a very valid point that my Lord Justice Newey made to my learned friend. Ultimately, in this case, as in many a tax appeal, isn't the focus really on the decision of the FTT? And I would concur, you're absolutely right, my Lord, in this, as in many a tax appeal, particularly those of a fact-sensitive nature, those that involve an evaluation of a fact-sensitive nature. Yes, the focus must be on the decision of the FTT. And that's why in our submissions, both I and my learned friend spent some time taking you through that. And that's where I'd like to turn next, please. Don't bother turning it up for the minute. We can dip into it if we have to, but I'm hoping that will be necessary. And let me start with the way in which my learned friend summarised the revenues case before the FTT. He said there are two elements to it. He said, first, to a significant degree, there was dual use of, let's call them the hospitality areas within the Hippodrome premises. And the second strand, he said, because of significant dual use, the floor space-based apportionment was fundamentally flawed, relying as it did on a premise of exclusivity. Let me just take that in stages. Dual use. I mean, certainly the FTT made a number of specific findings of dual use when it dealt with the evidence. I took you through a few examples in opening yesterday. So we have findings of dual use. And those findings in and of themselves do not render the floor space-based proxy unreliable. What's called for is an economic analysis. We can see that from Aspinall's dual use, recognised by the tribunal, but nevertheless embarked on an economic analysis. An approach approved by Lord Justice Etherton in this court in London Clubs. London Clubs itself, a case where there was dual use, but an economic analysis was called for, and indeed St Helens School. So in all of these cases, it's the economic analysis that's key, and as part of its economic analysis, this is the real question for the FTT. As part of its economic analysis, did it grapple with dual use, and more particularly, the significance of dual use? And my learned friend put forward 3 reasons why that wasn't the case. He said, well, no, the tribunal here, it instead adopted some sort of counterfactual approach, a counterfactual analysis, relying on what Mr. Justice Warren had done in paragraph 76 of his judgment in St Helens School. Well, yes, there was an element of that in the tribunal's analysis here, but can it really be criticised? And sorry, I'm posing that question rhetorically, because the answer is no, it can't. Because that paragraph of Mr. Justice Warren's judgment was referred to and approved by Lord Justice Etherton, not when he was dealing with the facts of London Clubs, but when he was dealing with the legal principles to be applied in order to identify the economic use of overhead costs. It appeared in that part of his judgment. So, again, can the tribunal here be criticised for embarking on some counterfactual analysis? No. No. There's good authority for that approach. Further criticism levelled by my learned friend was that the FTT here had almost applied London Clubs by analogy, this rather blinkered approach. And again, with respect, there's nothing in that submission. I mean, the fallacy of the submission is revealed really by the absence of any reference to London Clubs in the tribunal's analysis. Refers to St Helens, refers to Aspinall's, no reference to London Clubs at all. And then it brings me to the third criticism, that the tribunal didn't actually use the words dual use when it came to its overall analysis. And it's true, it didn't. You've seen that. You've read just about the whole of the FTT's decision by now. So no, it didn't use those words, dual use. But the question is, reading the decision fairly and as a whole, did it grapple with the concept and significance of dual use as part of its overall analysis? And I'm not going to repeat at length the submissions I made in opening, but you will recall that the tribunal had in mind here the type of offering, the type of food and drink on offer in an ordinary casino. It contrasted that with the offering in the Hippodrome and made the observation that the scale, the nature was completely different. And that the Hippodrome would be a completely different animal without a food and drink offering of that kind. If it was merely intending to serve the gaming clientele, the food and drink offering would look completely different. So that all drives, that's all central to not only the economic analysis, but an economic analysis at which an appreciation and understanding of dual use lies at the core. I have nothing else to say about our first ground of appeal, unless you have any further questions for me. So I propose to turn now to our second ground, what I'm broadly calling jurisdiction. And I'd like to start, if I may, just by standing back from the technical legal argument for a minute and asking the question, another rhetorical one I'm going to answer, but asking the question, well, if I'm wrong on jurisdiction, where does this leave us? Where does this leave taxpayers, court system? Because if I'm wrong on jurisdiction, we either end up with litigation stretching into the sunset because a taxpayer puts in an override calculation, it's knocked back, litigated before the tribunal, taxpayer loses, put in an alternative, knocked back, on and on it goes. The alternative, the taxpayer said, tell you what, I'll put a dozen in. I think it's a suggestion that, not quite that extreme, but a suggestion that you came up with, my lord. We'll put a dozen in. What you then end up with is an incredibly long and complex hearing before the FTT. You've seen how long this hearing took, and we were only here grappling with one method. So this idea of protracted litigation, jurisdiction of the sort contended for by my learned friend or found by the Upper Tribunal to exist, actually only serves protracted litigation. It also leads to some rather odd results. My learned friend based one of his submissions on absurdity. And going down that same path for a moment, produces some very odd results. Compare this case with London clubs. So London clubs applied to use a floor space based special method. And it won. Found that fine, can. So the commissioners now don't like the result, and they serve London clubs with an override notice, a special method override notice. If that special method override notice is served, what will be considered by the tribunal is not merely the adequacy of that method as a reliable proxy, but also what some alternative may look like. We see that from Vision Express, from the St. John's case. So what we end up with, materially identical cases, a casino that wants to use a floor space based apportionment. But when it gets to tribunal, the focus of the appeal is radically different. And in our respectful submission, there's no warrant for that whatsoever. And just one point in passing within a side, the method that is in issue here is not the first method that the Hippodrome has proposed. It's proposed at least two methods prior to this floor space based apportionment. In each case, the commissioners have said, no, we don't think it works. And in each case, the Hippodrome's tried to address those criticisms. I mean, we now know, in the light of a submission that my learned friend made today, that whatever the Hippodrome tries isn't going to be sufficient. The submission he made, we think the standard method works a treat effectively. But here we have a taxpayer, it's doing its best. It gets knocked back, and it's no further forward. Can that really be right as a matter of policy? Or is there a construction of this legislation that allows the tribunal to grapple not only with the adequacy of the solution, but the severity of the problem? And we contend that there is. Now, turning to the legal aspect of this, if you will, my learned friend relied on 3 points in support of his case on jurisdiction. He said, EU law has primacy. He says, the only basis to depart from the standard method is if another method can be identified that guarantees a more precise determination. And one can only determine the use of residual costs by employing some sort of method. Well, I agree with each of those propositions. Don't take issue. But our response is that the standard method override legislation does just that. It insists upon the use of a method. If HMRC don't like the method that's been employed, they can assess. They've assessed here. It's a question I think you put to my learned friend this morning. They've assessed here. And in that context, why should this appeal be any different to any other appeal against an assessment, where, as you see from General Motors, the focus is on identifying the correct amount of tax that is due and payable? Unless you have any further questions of me, that's all I have to say on ground 2. Which brings me finally to ground 3. Let me deal first with this example relied on by my learned friend, the garage selling toy cars. To put that to one side. If the car room was selling toy cars because there was credible evidence that it was looking to compete with Hamleys, then there would be no problem with the method. But that's not the case. And this is why it comes back to the point that an appreciation of the observable terms and features of the business are key in determining the adequacy of a method. And that would be one of the material questions to be asked when looking at the observable terms and features of that business. So it's a bad example. But let me come to the bigger point. This is where my learned friend looked to attack the 1/3 figure. He said, well, we see this 1/3 figure, but it's not a material part of the tribunal's decision, the Upper Tribunal's decision. And so what if there's an error of law that's inherent in that finding, if the Upper Tribunal has, I think the way my Lady Justice Whipple put it, applied the standard method through the back door in making that finding. So what, he says, because this isn't a finding that's material to its overall conclusion. Well, he's right. It wasn't a finding that was relevant to its overall conclusion. But of course, it's a highly relevant finding if I'm right on jurisdiction. And it's for that reason it's a finding that cannot be allowed to stand. So, my lord, my ladies, you have my submissions in reply on grounds 1 to 3, and as we did in opening, I'm going to hand over to Mr. McGee, who's going to build ground 4.
Very much.
My lord, my ladies, my learned friend's case on this ground, his 3 points, all fundamentally boil down to the assertion that we get the wrong answer on our analysis, and therefore we should accept his strained interpretation of the legislation, and therefore that Thorne EMI says that we should follow his approach, because, he says, Thorne EMI says you must get the right answer. So, in order to deal with that, the focus of my reply is going to be on his point 1, why he says we get the wrong answer. And to set those submissions in context, I do first of all have to clarify our analysis on part 1 of his example. So this is the case where all the business entertainment is used for taxable, furthering the taxable business. And his explanation of our analysis is that you do a commercial apportionment of the £15,000 that comes out of the standard method, and you get a £7,500 recovery rate. That's not what our analysis, and where we say there needs to be a commercial apportionment. Where we say there needs to be a commercial apportionment is where the business entertainment is used for taxable and exempt, in order to determine the amounts to which it's used for taxable and exempt. So on his example, and on the hypothesis, you would actually be removing the whole 10,000 and getting 5,000. So to follow the logic of his example, you would take your £30,000 of inputs. You would then put it all through the standard method, and you would get 15,000. And then on the assumption that you have used it, whatever use means, it's a question I'm going to come on to very briefly, to make taxable supplies representing 10,000 of that 30,000, you would then cut that out and you would be left with 5,000. So in effect, an even more starkly wrong answer, he would say, than on his analysis. But this court can only identify that the answer resulting from our analysis is the wrong answer if it's already decided what the right answer is and compares it to that. And my learned friend's case on grounds 2 and 3 was quite strongly that you cannot assess the use of any inputs or of any without a method to assess that use. And the implicit use that his example uses is a value-based use. So I think it must be in relation to the value of the supplies made rather than necessarily the turnover produced from any of them. But that's obviously not a method that is directly warranted by the standard method. And so fundamentally, what his complaint is when he says that our answer gives the wrong answer, or our analysis gives the wrong answer, is a complaint that the standard method doesn't accurately reflect the use to which the building has been used to make taxable supplies. Because, he says, it's been used to make taxable, its extent of use to make taxable supplies on example 1 is, actually I'm going to start with example 2 as my learned friend did.
Can we just stick with example 1, because I'd like to understand. So you say that Mr. Donwall's method would end up with a deduction of £5,000.
No, I say that our analysis on his method, or no, our analysis of his example would end up with a £5,000 recovery.
Yes.
Whereas he said it was 7,500. Yes. I was just showing that it is actually more stark.
No, I follow that. So can I just understand? We start off with a cost of £30,000, and you say on your method, as worked through, you end up with a deduction of 1/6.
Yes, if it's correct that you can measure the use to provide business entertainment by reference to the values.
Now, why would it make sense to have a deduction of 1/6?
Because, my lord, that's why we say that his complaint is fundamentally a complaint that the standard method hasn't accurately reflected use. That on our analysis properly applied, what you would do is you would look at your standard method calculation and you would take out, and the first of all, the thing you would do would be to say turnover and say that the turnover is the same as the value. So that we have £1,000 sales taxable, £1,000 sales exempt. And you would say, okay, 50-50, start off with our £15,000. We then need to do a restriction for business entertainment. How you do that restriction, how much of the input that is used for both business entertainment and for business generally isn't a question that's answered by Thorny MI. It has to be a commercial apportionment, I think that's clear. But if it's all of it, and say it's correct that £10,000 of it is being used to make being used to provide business entertainment, there would be a further reduction of £10,000. And so you would end up with the result of 5,000. But what we would say is that that would show that the standard method hasn't accurately reflected the use of the building to provide taxable supplies, because it has assumed that it's used 50-50. But there would at least be a possibility that it's actually being used more than 50-50 for standard, so that a greater than 50% of the building's inputs are being used to make taxable supplies, if there are not only the taxable supplies of 1,000, but also the business entertainment of 1,000 that furthers that taxable supplies. So, on our case, a further subset of use for taxable business. So if the £5,000 answer isn't right, that's not because our analysis has gone wrong, but because the standard method hasn't accurately reflected the use of the premises to provide business entertainment. And similarly, on example 2, this is the example where it's all used for exempt business. If the £15,000 answer, the final result, isn't right, that's because the standard method hasn't accurately reflected the use to provide taxable supplies.
Can I just stick with example 1 again for a moment? So you say, well, the problem would lie in how the standard method is being used. So how do you say the standard method should be used in that scenario?
I think, my lord, if the standard method goes wrong, that's where we fall into the override and the special measure.
But for this part of the argument, we're assuming we're applying the standard method, aren't we?
Yes, my lord. But in order to assess the validity of my learned friend's example, we need to see whether or not that is the result you would get. And our submission would be that if you say that's the wrong answer by judging the use of the premises, not by reference to turnover, as the standard method tells you to, because turnover would tell you get £15,000 out, but by assessing it in relation to values, the £1,000 value of taxable supply and the £1,000 value of business entertainment. It's difficult to see how you're measuring that without a method that's implicitly saying, well, giving away £1,000 worth of champagne is the same as selling £1,000 worth of champagne.
Is there any way in which your method coupled with the standard method could come up with a sensible answer?
Yes, my learned friend. Yes. And it does produce a sensible answer in most cases.
Well, sticking with scenario 1, I just want to understand scenario 1.
Well, I think where we would then go to is that my learned friend makes the point about the flexibility of the standard method. And that's another part of our argument. It's the point we make at paragraph 66 of our skeleton argument, which is that as you do business entertainment to further your taxable supplies, the turnover of your taxable supplies should, in theory, increase. That's the reason why you've done it. You want to sell more bottles of champagne or whatever, so you give one away in order to drive further business. And so we would say that as that happens, the £1,000 of taxable business is increasing. And so that the business entertainments should be reflected in that increase. It's one of the reasons that we find the example quite difficult, because it's unreal, because it assumes that it doesn't engage with the fact that it's increasing that £1,000, or if it's not increasing it, it's been necessary to make that £1,000.
But in any particular period, you will have certain figures. You may hope to get different figures the following year, but we assume, for the purposes of this discussion, I think, that in the particular accounting period, we have £30,000 of expenditure and the three-way split of supplies.
It can't be a three-way split of supplies because we're giving away the business entertainment. That's our point, that there's not a three-way split. There's effectively a two-way split on part 1.
All right.
You have two.
So you get the point. So how do you get a sensible answer on your case?
So we would say that on part 1, what you're doing is you are using the premises to 2/3 to further your taxable business, because you've got the third to which you're using it directly in sales. You've got the third by which you're using it in business entertainment for your taxable business, and that's your 2/3. Now that 2/3 won't be reflected in the standard method, because the standard method will only look at the sales. That's the only bit of turnover. But the example shows that there may be deficiencies in the standard method in cases where you have got substantial amounts of business entertainment in a partially exempt case. So you may need to use the sorts of...
No, we're not. We're on the standard method for the purposes of this argument. So if you apply the standard method, what do you get?
If you apply the standard method, you get the result of 5,000. But for the purpose but in testing this argument, we do have to see whether or not it's realistic. And in order to complain that the result is wrong, you have to say that the standard method is not accurately measuring the use of the premises. I'm not saying that necessarily you would then use an override calculation, because as you say, we're on that premise. But in order to say that the example is wrong, his measurement of the use of the premises isn't the standard method's measurement of the use of the premises. That's 15,000, 15,000. It's 10,000, 10,000, or 10,000, 10,000, 10,000, based on values, which is not the question that the standard method asks. And so, similarly, in example 2, we would say that, again, what's happening is that this standard method is not reflecting that 2/3 of the use is actually driving taxable sales, if use is correctly measured by values, if that's an appropriate measure of use, which is going to be a question that has other factors to it.
Doesn't that undermine Article 5, which tells you in terms? It doesn't say you look at why you're business entertaining. It just says if it's attributable to business entertainment, you can't. It's excluded from credit. So why does it matter what you're using your business entertainment to do?
Because, milady, the fact that you've already used your business entertainment to produce exempt supplies. In example 2, the measurement of your exempt use has already all been carved out.
As I understand it, Mr. Donald will correct me if I've got this wrong. He only goes down this line of let's do the pretend examples 1, 2, 3 to answer your case. He starts in a completely different place. He says you don't even look at why you do this business entertainment. All you do is you work out how much you need to take out of the sums before you even start them.
My learned friend started with I don't want to get into who started where, but he started with the example.
He's answering your case and saying your case doesn't work. And now we've heard you say, oh, yes, it does. It's because his predicate's all wrong because he's on values and he should be somewhere else. I don't think he starts in the same place as you.
My lady, he starts with the examples in order to show that our case on the legislation doesn't work. And then in dealing with his example, that's why we then get into this question. So my learned friend accepts that our submissions on the legislation is at least a natural reading. Hints in it that it may be the more natural reading when he talks about technical reasons, and nevertheless we must go to EU law in the now no longer pursued argument. And so when we then take this example that's said to show the absurdity, we see that actually the example doesn't show absurdity because the example itself doesn't really take us anywhere.
Actually, what would really help me, as you can tell from my face, I'm not finding this an easy gig. Can I start in a slightly different place? Okay. And I think what I'm going to ask you, Mr. McGee, to do with Mr. Donwell is put something in writing, some figures that actually are real figures. So can I I say this because you can tell me I've got it all wrong, but I think where we start is with what the residual tax for your client actually was in a given year. And I think that's the chart on page 181, which is one of the appendices to the FTT's judgment. And if we just take 1 year, because we've looked at 2014, and maybe that's enough just to illustrate things. So my first question to you, Mr. McGee, is, am I looking in the right place for an example of what the residual input tax actually is? And I've got a figure of 1.22 million. Is that the residual input tax for 2014, which is the thing that we're arguing about?
Yes, I think that's right.
So let's not have hypothetical 30,000s and then, hypotheticals. I think I'd find it easier if it was real stuff. So if that's the residual input tax, I think the question then under Article 5 is where and how do you take out of that figure what you think you have, the bit that is used or to be used for the purposes of business entertainment. Is that a hard figure? Do we know what that figure is, or is that? I
think there may be some trickinesses in the figure because of the predominant point that the FTT
is that capable of agreement, or are we in dispute about the predominance point?
I think we can probably at least come up with an example sort of percentage that we can use for working it through. He said.
I would like to see this figure, if I may, work through by both of you, just to see how it comes out in the wash in the end, And you may need to put a little bit of narrative to explain what you're doing at each stage and why you're doing it. Because I think we've all got the broad parameters of this debate, but speaking for myself, I'm just struggling to see how it actually works out on the facts of this case. Yeah?
Yeah, absolutely. So, it's a question for both of you. Are you happy to prepare such a document?
It's certainly. I mean, for my part, I think the one point I would note is that that exercise has not yet been done because that element of business entertainment restriction in respect of 2014 isn't live. The business entertainment point, boringly, in a way.
Okay, is there a better year that we could use to do that exercise?
Has actually come into effect.
And it may have been done, maybe I've missed it. Or it's
no, it's in respect of the CGS adjustments.
That's right, so it's not even. It's not
exactly.
even page 181, it's the CGS
Yeah,
adjustments.
exactly. So it is...
so it is a bit hypothetical.
I think it is a bit hypothetical. The other point is that, in a sense, if I understand my learned friend's response, he agrees with the outcomes on my analysis, save for that he says it's 5,000 rather than 7.5. But he agrees that those are the outcomes. But then he says what that shows is that the standard method is not working right. So we, in a sense, what this exercise will show is an outcome on the basis of you using a standard method. But then my learned friend will say, but in any case, we don't accept the premise that it's being used as a standard method. So we don't. I'm not sure we'll actually.
I don't think it's going to cure anything. It
No.
just might help me understand
indeed.
what the
And so I
passage is.
think, if I understand my learned friend's point, his basic point is, if you read this legislation in the way we ask you to, so you go to 26 first, in scenarios where the standard method is applying and there's business entertainment in a significant part, the standard method will always produce the wrong answer. So in a sense, he's basically saying the business block won't really work in conjunction with the standard method in a partial exemption situation. We say, well, that is also problematic if that is the conclusion, because it works perfectly straightforwardly if you just do the entertainment block first. So, my lady, I want to be.
Is there any
assistance to
help?
the court.
Yeah, I'm just. You can see where I'm struggling a
do.
little bit. Is there anything I can have on a piece of paper that just helps me to work these arguments through? I understand. I've forgotten it was just CGS, just capital goods scheme, residual tax on items that are in the capital goods scheme. Would that be leases and things? It's big ticket items, isn't it?
It's the reconstruction of the hippodrome as a whole.
Yeah,
it's building.
It's the building work.
Can we extract anywhere figures for that could be worked through, or is that not going to work?
It probably will. The ultimate actual differences are pretty. It's a big point of wider principle of this business entertainment, but certainly we can try together and try and find a way of articulating the scenarios in a way that assists. It is possible that we can't agree, but we will try to.
And it would certainly be useful if you could find a way of articulating the scenarios by reference to real figures rather than hypothetical ones.
My lord, yes.
Yeah.
Can we, just in respect to the time frame for that?
Yes. Can I leave that for one moment?
Yes.
Let's
hear the rest of the reply. Yeah, thank you very much.
Mr.
Sorry
McGee,
to have taken
we've obviously covered quite a lot of the ground. What ground remains to be covered?
Fundamentally, it's that unless you accept that we have the wrong answer, which is only to be produced by reference to deciding that the hippodrome or the hypothetical premises are used in a way that is not, that the standard method does not reflect, that Milan and Friends case gets off the ground. And so if you don't accept that we have the wrong answer, and that wrong answer isn't cured at some other stage in the process, then Milan and Friends case falls and here on this ground.
I mean, I think the overall picture is, as you say you have a perfectly logical way through the statutory provisions. Mr. Donmall doesn't exactly say that isn't a perfectly logical way through the statutory provisions, but he says it just can't be right, and you say, well, it can be.
Precisely. We say that his way through the legislation doesn't work. But
Yes.
yeah.
So really, is it only the question of when it might be possible to produce this extra document? Well, I got the impression Mr. Donmore might have some practical difficulties.
Well, I'm just cautious that it should assist the court rather
Yes.
than otherwise, and I haven't had an opportunity to discuss with my learned friends why, when it could be done.
No.
I should,
Just I may need to take instructions.
yes, exactly. We wish to assist. I personally do have difficulties if it's going to
Yes.
be produced in more than a week, as it were, because of other commitments.
So when might you, without undue inconvenience, be able to produce?
Well, if a week works for you and more than a week doesn't work, let's go for a week.
And we're on Wednesday, aren't we? Yes. Let me just. Today is the 25th. Next week must be the 2nd, must it? So would it be possible to have a document by close of play on the 2nd?
And just for clarity, to whom should that document be?
Do you have the email addresses for our clerks?
We certainly have the email address for Milady's clerk.
Yes, that's
Thank you.
And so, subject to that note, those are my submissions.
Thank you very much. Well, you will be surprised to know, especially in the light of our discussions, that we're not going to give judgment here and now. You will receive the draft in the normal way for you to correct our English and typing, but not to allow you to re-argue the points. We'd be grateful if at the same time you would seek to agree an order dealing with consequential matters. If there are points on which you can't agree, could we please have brief written submissions, and we would expect to settle the points in the order that we make. I ought finally to remind you all of what you will already know, which is the importance attached to the embargo. If you think of anybody extra who ought to receive a copy of the draft, you obviously need to come back to us. A failure to comply with the embargo is taken very seriously. Thank you all very much for your very helpful submissions.
All right.